Model Rule 3.8 sets forth some special ethical duties or responsibilities for prosecutors, those who represent the government in bringing criminal actions against individual defendants. Rule 3.8D, which is a subsection we're going to talk about in this video, is about special duties to disclose information that might in any way be helpful to the defendant. In other words, you have to turn over information that they don't know that you know that might help their side. This can kind of create friction with a lot of people's intuitions about strategy and trying to win their cases, but it's a very strong duty. This also overlaps with a line of Supreme Court cases, starting with Brady versus Maryland, that we're going to talk about too, so that you don't get them mixed up when it comes time to take the MPRE or your law school exams. I'm Drew Stevenson. This is for my professional responsibility class. Let's dive in. So as I said, we're talking about disclosure rules and Brady violations under Rule 3.8D of the Model Rules of Professional Conduct and the old Supreme Court case, Brady versus Maryland. So 3.8D starts by saying a prosecutor shall make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. And notice the words that I put in bold. You have to do it timely, in other words, typically before trial or as soon as it becomes known to the prosecution. You're only responsible for information that you actually know as a prosecutor, but notice the sort of low bar for anything that could even be a little bit helpful potentially to the other side. And wait, there's more. In connection with sentencing specifically, you have to disclose both to the defense and to the court or the tribunal all unprivileged mitigating information known to the prosecutor, with the exception of when the prosecutor is relieved of the responsibility by a protective order of the tribunal. So, and remember, this is an exception that runs all through the model rules. You probably will never be subject to discipline if you are acting pursuant, simply obeying a court order. The court orders you to do something and you do that thing. Generally, the model rules will say that you won't be subject to discipline. But if that hasn't happened, you have this duty to disclose, not only related to guilt and kind of the gradation of offense, but anything that could be a mitigating factor at sentencing. And the comments to Rule 3.8, really only one of them is about subsection D, and that's comment 3, and it says, the exception in paragraph D recognizes that a prosecutor may seek an appropriate protective order from the tribunal if disclosure of the information to the defense could result in substantial harm to an individual or to the public interest. So what are we talking about? The identity of undercover police officers, perhaps, or the identity of a confidential informant that gave a tip to the police, or maybe the location of the victim where they're trying to hide from retaliation or something like that. So there's a number of cases, situations like this, where we are trying to protect someone's identity, usually, so that they can't be targeted by the defendant or other people that may want to cause harm, or it won't jeopardize other criminal investigations and prosecutions that are underway. Okay, let's move on. Here are some recent examples from the last few years of cases where we either had a prosecutor be disciplined, which is admittedly rare, or we have an ethics opinion kind of opining or weighing in on something specific that a prosecutor did. First example should have been an easy one. The victim of the crime recanted their original story. Well, obviously, the defense would need to know that the victim has changed their story. The prosecutor didn't disclose that, and they should have. In another case, there was a police officer who was involved and maybe testifying, and the prosecutor knew that that police officer had been found to be lying during an internal police investigation. And it could have been about something else that wasn't exactly what they were saying in the case, but either way, it's valuable impeachment evidence. It should have been turned over. In another case, the prosecutor, but not the defense counsel, became aware of the defendant's diminished capacity, maybe because of medical records or psych evaluations or something like that. In another case, a prosecutor had formerly in their private practice represented someone who was going to be a star witness for the state in a case. Well, that may not be something that's serious enough of a conflict, given this, depending on the circumstances, to disqualify the prosecutor from the case, but it should have been disclosed anyways. And the another case was about a prosecution for basically public contracts and corruption. And one of the prosecutor's big campaign donors was involved with the case. Well, that may not mean that the prosecutor can't do the case or that the defendant is innocent, but it's still something that should be disclosed. Even a simple thing like the prosecutor, their vouchers, that how much they are giving to different witnesses for the prosecution to cover their meals or lodging or things like or travel and so forth to the trial. You're allowed to do that, but you have to disclose it and disclose how much is given to different witnesses. Okay, now let's talk about Brady violations in this case. And the big takeaway here is that the Constitution, the Due Process Clause of the Constitution, requires prosecutors to provide the defense with any favorable evidence that is material to guilt, punishment, or impeachment. And this comes from a case in 1963 from the U.S. Supreme Court, Brady versus Maryland. And in that case, it's sort of egregious facts. We had co-defendants who were being tried separately, and one of them had given a full confession to a murder, taken sole responsibility, and essentially their confession exonerated the other defendant. And the prosecutor never told the other defendant that and just continued with the case and got a conviction. And so the Supreme Court said you can't do that, right? And this could be grounds for reversal. It's such a violation of due process. And so again, notice that under the standard, it had to be material evidence. And in subsequent cases, especially United States versus Bagley in 1985, the court said evidence is material if there's a reasonable probability that if the evidence had been disclosed to the defense, the result of the proceeding would have been different. In other words, did this really make a difference to the outcome of the case? And I also want to pause for just a moment here, make sure my students understand an important difference here between the rule and the Brady doctrine and Rule 3.8. Rule 3.8 is an ethical rule that could make the prosecutor subject to discipline from the bar. But violating 3.8 is not in itself going to be grounds for appeal to try to get a reversal of someone's conviction. A Brady violation, in contrast, is exactly that. It's the grounds for appealing a conviction and trying to get it reversed, but it may not have any implications. The state bar might not do anything about a Brady appeal. So keep in your mind that there's these two rules, when they're violated, kind of go off in different directions in terms of how we're going to enforce them. So let's go back to our slides here. The Model Rule 3.8 has a different standard, and hopefully you picked up on that. Instead of material, which is what Brady versus Maryland said, material evidence, Rule 3.8 says it requires disclosure of information that even tends to negate the guilt of the accused or mitigates the offense. In other words, 3.8 is stricter or requires more disclosures from the prosecutors. The Supreme Court has actually noted this difference, the overlap and distinction between the two. So in 2009, we have a decision, Cone v. Bell, where they said, although Brady only mandates the disclosure of material evidence, there's a duty to disclose other evidence that may arise under Rule 3.8d. In an earlier case, 1995, Kiles v. Whitley, the Supreme Court said that Brady requires less of the prosecution than Rule 3.8d or the ABA standards of criminal justice. What this might mean in practice is that if the court is going to find a Brady violation, the Brady violations are basically a subset. The information that would have to be disclosed is a subset of what you would have to disclose, I'm sorry, of under 3.8D. In other words, if you violate 3.8D, you may not have committed a Brady violation. But if you committed a Brady violation, you've probably violated 3.8D as well, even though sanctions from the state bar for these types of cases are really rare. Now, another thing that you should understand about how the Brady doctrine works is that Brady and that sequel case I mentioned, Bagley, adopted basically a two-pronged test, very similar to the Strickland rule for ineffective assistance of counsel. And like Strickland, most defendants are going to lose at the second step or on the second prong. Remember, we have kind of two questions an appellate court would ask. First, due process requires prosecutors to disclose material exculpatory evidence. So we're going to ask, did that happen? And then we're going to define material as the reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. So I'm translating this, though, into sort of a checklist for you when you're in practice to understand what's happening. So first, an appellate court or reviewing court, when a conviction is appealed, is going to ask, did the prosecutor withhold any material exculpatory evidence from defense counsel? If not, we're done. If so, we go to the second step, and we have to ask if that violation probably changed the outcome of the verdict or the outcome of the case. And to be honest, usually we are going to lose at that step, because if the record contains other substantial evidence of the defendant's guilt, so an eyewitness picked them out of a lineup, someone else testified against them, things like that, then reviewing courts will basically assume that the defendant would have been convicted anyway. So, and usually there is other evidence, substantial evidence of the defendant's guilt. Why? Well, prosecutors probably have to have probable cause in order to get an indictment. Under other ethical rules, are supposed to have probable cause, you may remember, under other sections of 3.8, to even bring a prosecution. And the police, in theory, have to have probable cause to get an arrest warrant or a search warrant in a lot of cases, unless certain exceptions apply. And so usually there is some other substantial evidence. And if so, then the court is going to say, well, the jury would have found you guilty anyways and won't reverse the conviction. And that concludes our little lecture about Model Rule 3.8D, which is a disciplinary rule. It's a rule, violations could subject a prosecutor to discipline under the state bar, versus Brady versus Maryland, which is a constitutional rule that is about whether you had sufficient due process at your trial or if the conviction should be reversed.